Now I think we should begin the session.
Hello, sir. Hello,
So,
sir.
noon, yes. So now I think we should begin the session. And good afternoon to all of you.
Hi, Nishi. Just give me 1 minute. Yeah, sir is now live. Please start.
Okay. Good afternoon, sir, and good afternoon to everyone who has joined this session. Thank you for joining the session. And before starting the session, I would like to give a slight introduction about myself. I am Rini Mishra, and I'm a first year law student. And currently, I'm also an associate at EduLaw. To describe EduLaw in a few words, I would like to say that EduLaw provides legal education by closing the gap between theory and practice. And we bring business knowledge into the world of legal education, making it simpler, quicker, and more affordable to master the practical skills that one needs to interact with clients more effectively, swiftly, and economically. We are constantly updating our legal dictionaries, legal maxims, legal icons, legal codes, discussion forums, codes, important cases, and much more. You can also check our website link that has been sent and it has been posted in the comment section below. Now, I would like to welcome Nishant sir in this session. We were all looking forward to this session, and now I would hand over this session to Nishant sir. And thank you a lot, sir, for joining.
Thank you, everyone. First of all, I introduce myself. Myself, Nishan. I have completed my LLB from University of Pune, and I have currently I am pursuing my CS Company Secretary. I am a CS final, as well as I am pursuing my MA from Nalsa University of Law, Hyderabad. So basically, my practice area is corporate and criminal. Uh, and Just a second, what happened here? Yeah. Hello. Yeah. Am I audible to everyone? Yeah. So I run my own farm. My office is at Mandi House, Bengali Market. So basically, today I have been invited to speak upon the topic UAPA and the rise of cases and fall in conviction. So without delaying any time, I should start the topic about what is UAPA and all the things about the topic further later on. So before starting UAPA, the first thing is what is UAPA Act is all about. Okay, so when we talk about the UAPA Act, it's called Unlawful Activity Prevention Act, which was enacted in the year 1967. So everything which I am covering here is already on record, and I don't want to speak upon anything which is political and which is sub judice in the court of law. So all the things which I am delivering here, I will give you the link, and I will provide you all the details where you can also read the cases and the references. So the very act was enacted in the year 1967 at the time of Indira Gandhi government. So basically, what is the main objective of bringing that law? So we have seen that there are so many associations who speak anything about the country. If we take the example, initially at the time of after independence, there was a political party. I don't want to take the name of the political party. So the political party was talking about that when it comes into power, he will divide from India. भारत से अलग होना चाहते हैं. So such kind of things are in the name of freedom of speech. We are not allowed to speak anything which is against the dignity and sovereignty of our country. So the main purpose of this law was to bring for this to curb this purpose. So if I read the main Bare Act line and the object of this act, uh, to bring a reasonable restrictions in the interest of the sovereignty and integrity of India on the freedom of speech and expression, right to assemble peacefully and without arms, right to form associations and union. The objective of this bill is to make power available for dealing with activities directing against the integrity and sovereignty of the country. Okay, so thereafter, if talk about anything, the first question arises in what is called unlawful association, because the unlawful activities about from an association after the 2019 amendment, it has come that a single person can also be named under this law under section 35 and 36. Under section 35, he could be named and put in the into the fourth schedule of this of this very act. But what is unlawful association? So I don't want to go into the detail of of the bare act. I just want you to refer section 2 subsection P of UAPA Act. Okay, so before going further, I would like to so there were two acts. Initially, there were TADA, who was the act was made for to curb the terrorist activity. So the TADA, initially this act was not covering the terrorism part. So initially there was TADA. Thereafter POTA has come. You all might be knowing about in the time of Atal Bihari Vajpayee government, quota has come, and there was so much hesitation in the from the opposition that this act is very arbitrary. This act can bring like someone has said that this act is not less than the Rowlatt Act, on which the General Dyer has killed so many people in Jallianwala Bagh. So thereafter, we have seen in 2004 when UPA government has came into power. So what he has they have done, they have repealed the POTA, and they have bring more or less the same act of POTA to UAPA. And they have amended chapter 4 of the very act, and they have included terrorism and all the things thereafter. But so the major amendment was done in 2004, and thereafter the major amendment was being done in the year 2019. There also there was so much agitation from the opposition that this act is draconian and so many things. So the three major amendments which was enacted, which was amended by the Act of 2019. The first act was enacted that NIA has been given power to investigate the cases. And how the NIA investigate a case? Upon the request of the state government or the central government, take a suo motu cognizance and take the case and investigate any case which has been registered under the UAPA. So basically, we want to know here that how a case is being registered under UAPA. It is not act like IPC or any other act, any other penal act, like police can easily charge. You have to take the sanction of the state government or the central government, as the case may be. So as the so according to that case, after the sanction of the state government or the central government, the UAPA charges has been applied upon the person. Okay. So, what happened in the year 2019? The three major amendments has been brought down, and three major amendment on which the main concern which has been raised, that initially it was said that the association, any unlawful association would be named and it could be charged under and it could be banned under UAPA. But what happened after the amendment of 2019, that under section 35, any individual can also be charged against can be claimed against the and put under the schedule 4 of the UAPA Act. Like the main reason of bringing this act was the amendment was, there are so many persons that we have seen in United Nation also, there are so many. Hafiz Saeed was being declared as a terrorist. So thereafter, individual can also be named as a, so accordingly we have made our amendment that individual can also be named as a terrorist, and he or she could also be put under the schedule. Okay. So the main thing which arises here, the main question which has been arises, that what are why this act is different from the other acts. We know under section 167 of the CRPC that a person cannot be put into the police custody for more than 15 years. Sorry, 15 days. I'm sorry, 15 days. But in this act, under this act, a person can be sent to custody for 90 days, 30 days to 90 days in some cases, as per section 43D of the UAPA Act. And the timing, the date of filing the charge sheet is 180 days. So the period has also been increased. So and there is no provision of getting the anticipatory bail, and the provision are so much stringent that a normal person, if a person has been charged under the UAPA just for a mere suspicion, it would be very much like impossible for the person to get bail. So the main thing arises that what are the challenges before us after the 2019 Act. So here I have mentioned some of the charges, some of the points uh, on which the amendment is being challenged. The new amendment is contrary to the principle of innocent until proven guilty. It infringed the International Convention of Civil and Political Right 1967, which identifies the stated principle of universal human right. Thereafter, no intention basis has been concocted for categorization. The government has been provided with unfettered authority to hold an individual as a terrorist, just like I have mentioned section 35 of this act. The UAPA is a part of a scrutiny legislation enabling the government to arrest citizens who might commit crime. It is problematic legislation for various reasons. If you see section 10 of the UAPA Act, the main problem arises from here, where penalty for being member of the unlawful association. So who is called the member of any band organization? So if we see, like we all have come to join this webinar, so we all have gone through a link. We have clicked on a link where, through that we are participating in this webinar. So when a political organization, when any member is called as the member is called the member is will be held as a member of an unlawful assembly, it means there is no fixed criteria that how the person is called as the member of this. Later on, I will share some cases on which Supreme Court or High Court or different high courts have observed and observed that what is men's what would be the mens rea in this case. Okay, so later on, if I come to the other points on which it has been challenged, it does not tolerate dissent. It criminalizes mere thought of the political remonstrate that provoke disaffection with the state. That is, it is outslot of the citizen right to express a mutual right of group and unions to propagate their views under Article 19 of the Indian Constitution. So here we say, if I am speaking against the government, and if government is not if government feels that कि, वो बंदा मेरे लिए politically it might be dishelpful for the person politically, so he can put charge. And we have seen cases recently. I'm not commenting upon any political party, because it is very much problematic for me as well to speak upon any political party. So the next thing is, it can be utilized to circumvent fundamental rights and procedures. For example, without even a charge sheet, those arrested under the UAPA can be detained for a period of 180 days. Therefore, directly violates Article 21 of the Constitution. Means a person can be put behind bar without, and we have seen there are provisions under the UAPA that where it is not necessary to show the witness that upon whom the case is relying upon. So there are so many chances that who is the witness, whether the person is politically motivated, and what are the things, because this is the basic principle of criminal jurisprudence, that any person who any trial which is being conducted, it should be conducted in the person should know that who is speaking against him. so that he could so that he has a right to cross examination and all the things. So thereafter, thereafter the other point is it bestows upon the government vast discretionary power and also imparts the creation of a special court with the ability to use confidential witness and hold cross door hearing, which I had discussed right now. It is being practiced to satisfy dissent through coercion and harassment, thus imperiling the very existence of the public debate and freedom of press and criminalization and enforcement of the civil liberty. That uh, so if I come on onto the next point that on which this act has been challenged upon, so I would like to refer some cases before you. The case is Makbul Fida Hussain versus Rajkumar Pandey. It's a case of 2008, where Honorable Court has said it gives government discretionary power to curb of silence, dissent, and opposition voice. So basically, it is infringing a person's Article 14, 19, 1A and 21 of the Indian Constitution. Thereafter, yeah, thereafter, a case which is pending in the court of law is Sajal Avasti versus Union of India and Association for Protection of Civil Rights versus Union of India. In this case, the parties have challenged the amendment of the 2019. It says that the overreaching argument of both petitioners is that an individual may be identified as a terrorist without any judicial scrutiny and even before the commencement of a trial. Thus, they challenge the Amendment Act of being violated of the right to equality under Article 14, free speech under Article 19, and the right to life under Article 21. As per the Avasti petition, the right to equality is violated since the provision does not provide any detailed grounds based on which one may be categorized as a terrorist. For this reason, the provision is manifested arbitrary. The doctrine of manifested arbitrariness, in brief, states that if a law is made without an adequate governing principle and is excessive of disappropriate in nature, the same is manifestly arbitrary and thus antithetical to the right to equality. Thereafter, if we come to the other part, uh, just wait for a second. Yeah, just when we come to the other part on which the cases has been held and the court has decided upon upon the principle that because there is a very good principle in our court of law that 100 guilty person can be acquitted, but one innocent person cannot be sent behind bar. The meaning thereby of the principle is that. So the main problem which arises to for the lower conviction is here are some of the points on which the circumstantial evidence. In most of the terror cases, direct evidence will be rare as an act constituting the offense is executed in a discrete manner. Therefore, the law related to the circumstantial evidences has very much importance. But in general, we have seen that circumstantial evidence is always weaker than the direct evidence. So, in the case of Hukum Singh versus State of Rajasthan, in the case of Ira Bhadra versus State of Karnataka, State of UP versus Sukh Basi, and Balwinder Singh versus the State of Punjab, the circumstances of which an inference as to the guilty of the accused is drawn have to be proved beyond the reasonable doubt and have to be shown to be in closely connected with the principal fact sought to be inferred from those circumstances. In Bhagat Ram versus State of Punjab, it was laid down that where the case depends upon the conclusion drawn from circumstances, the cumulative effect of the circumstances must be such as to negative the innocence of the accused and bring the offense home beyond the reasonable doubt. So when it comes to conviction, the court has to the prosecution has to prove the case beyond the reasonable doubt. So there was another case of Ray in the case of Muddama Malla Reddy versus State of Tamil Nadu. in that case, in that case, court has said that it is the responsibility and duty of the investigating officer to protect the right of every citizen. Because what happened in this case, a person has been arrested on a mere suspicion, and upon court has said that it is the duty of the police to protect the right of a citizen. Because after all, when anything bad, anything happens, we always goes to the police, and if the police does not protect our liberty, then to whom we will go? Later on, in the case of in the case of state of Maharashtra versus Mirza Himayat Beg, uh, a divisional bench of Bombay High Court has said that recovery of explosive from the accused itself is not sufficient. In the High Court has held that major circumstances such as nature of the accused, his mental aptitude, his approach towards life, his awareness, his jihadi tendencies, his conduct of motivating with two cell phones, some false documents in themselves do not establish the evidences against the accused of his involvement into the offences against UAPA Act. UAPA. The prosecution case herein that accused conspired with other accused to commit terrorist act in the German bakery in Pune, manufactured bomb and helped the planter Yasin Bhatkal for planting it inside the bakery. RDX and other articles were recovered from the accused. The conviction imposed by the trial court offense was set aside by the High Court, upholding even if it is assumed that the accused was in possession of such document, and the same could be a circumstance of itself, but such circumstance would become incriminating only when the prosecution discharges its duty and bring relevant factor for conducting all the circumstances of the activity of the crime. That like we have seen we have seen some we have seen in newspaper and in news also that a person has been charged under UAPA just to some pamphlet has been recovered from his house. We have seen a very horrific case of Bhima Koregaon case where Stan Swami was being is has been died in judicial custody. A person who was of so old that he could not be able to take a glass of water himself, but he was not being discharged. So we can see the how horrific the case is all about. So later on in the case, in the case of RP Goyal versus Union of India 2004, Delhi High Court observed that knowledge is a not necessary in element to prove any crime, because the mens rea is a very essential element. I am not reading the whole emphasis which has been laid down by the by the Honorable Delhi High Court. We can see everyone can read the case of RP Goyal versus Union of India 2004. Okay. Thereafter, if I move further, yeah, this is a very important case. The expression reasonable cause to suspect appears to be subsection. This is all about section 22 of POTA. Cannot mean that the accused held merely a conjecture or surmise, and there should be convincing evidence that the accused readily believed or had reason to believe or should have good ground to suspect that the money would have used for the purpose of terrorism. Like if any person has come to our home and we have given some money to him, or we have seen some, there are so many links comes on website that donation, and upon that donation only, if someone has given some amount of money, and upon that money a person has been held that you are providing finance to the terrorism, it's not itself a single ground to declare a person as a terrorist or person to be convicted under this act. Later on, if I read the section, if I read the one more cases, one very important case, yeah, this is a case of Litte. In this case, a person, this is a case of High Court of, in Tamil Maran versus the Inspector of Police, Hausar Town Police Station. In this case, a person has gone to a blood donation camp, and he was been charged under UAPA. So court has said that court has very categorized conducting blood donation camp to mark the birth anniversary of Prabhakaran, who was the leader of Litte, will not amount to promoting or advancing the activities of the terrorist organization. At the best, it can only amount to expressing support to the banning organization, which has already been held to be not an offense by the court. Later on, in the case of Bandi Narendra Kumar versus State of Andhra Pradesh, it has said that in this case, a doctor who has treated a person who has treated a person. In this case, court has held that while dealing with the bail application of a doctor against whom the offense of supporting the terrorist organization was alleged for threatening a member of the committee, member of the East Sub-Zonal Command of PWG, the prima facie the act of the petitioner going to be the forest and treating the leader of a banned organization cannot be said to be an act falling under Section 21 of the Act, because he is a doctor and has a duty to provide treatment to an allying person, irrespective of the fact whether he knows that person is a criminal or a terrorist or a gentleman. Because meaning thereby court has emphasized that a person who is following his duty just like I am an advocate, and many of the person who are joining here are will be an advocate in the future. So you cannot be convicted for that offense that you are defending a criminal, fighting for justice, and you are fighting for justice, and you are representing the person that a proper justice should be served. Whether the person is guilty or not, that is not our concern. It is the duty of the honorable judge who are sitting and who are sitting to adjudicate the case to he or she is the proper authority to decide whether the person is guilty or not. So thereafter just wait for yeah. In the case, the Bombay High Court, the High Court of Bombay in Muhammad Gyansuddin, son of Wali Muhammad, was a state of Maharashtra. It says that Section 2 of the Pota and held the person must be have a requisite knowledge of at least has been a reasonable cause to suspect that the money or property will be used for the purpose of terrorism without an knowledge. So we all have earlier discussed that knowledge is the main essential ingredient, and the mens rea should be proved that the person is not the whatever has been happened out of he has knowledge and he has committed an offense. A very important case of Kartar Singh, in which court has specifically said, unless a statute either expressly or by necessary implications rules out mens rea, in case of this kind, the element of mens rea must be read into the provision of the statute. Meaning thereby, court has specifically said that mens rea is a major ingredient to make any person convict under this section, under this very act, because a mere membership, there are so many organizations we all have seen, we are in young age, and there are many cases that we get fantasized by some organizations that he is doing good, he will change the entire scenario, and he will change the country and blah blah blah. So upon that aspect, some person made a believe, and he has not done anything which is contrary to the law, could not be held liable and could not be held guilty under this very act. Basically, after discussing all these cases, we have come on a conclusion that we have to see that whether the person has actively participated, whether the person has done something, whether the person has spoken, whether a person has spoken. There is a thin line that what is the reasonable restrictions and what we are trying to or we are provoking. Just like if a person of any other part of India has said something wrong, it does not mean that he does not love his country. It shows his it can also be possible that he is showing his aggression. Showing aggression cannot be said that a person is held guilty under this that he wants to break the country. This is the matter of adjudication, and courts are supposed to do adjudicate the cases, that whether the person is guilty under this act, whether the person is really wants to break the country, and all the things really. And in this case is like we have discussed the case of Sajal Avasti, that government should also look upon these issues, that by curving the by putting a restrictions, we are not supposed to curb the fundamental right of any person. Like if we come on the next part, hate speech and section 153. Hate speech, what is hate speech? Like we have seen the Haridwar Dharm Sansad. It might be very much problematic, but yeah, at least we should discuss this case. So, Dharm Sansad case, in which there have been so much hate speech was being made out by some of the persons, but still the UAPA Act was not charged against them. So we can say that whether or there are so many cases. I don't want to. Yeah, I want to show you one more judgment upon which Delhi High Court has, while giving bail to the person, while giving bail to the persons of yeah, in who are protesting for CA and NCRB. In that case, and there are other cases on which, yeah, this is the case of Mazdoor Kisan Shakti Sangathan versus Union of India. The court said that uprising against government and parliamentary action are legitimate, though such protests and assemblies are supposed to be peacefully and non-violent. It is not new for protester to dangle with the limit of law and protest to take a violent turn. Even if we assume for a sake of argument, without expressing any view thereon, that in the present case, inflammatory speech, chakka jam, in instigation of women protesters, and other actions crossed the line of peaceful protesters, permissible under our constitution, guarantee that however would yet not amount to commence to a terrorist act or a conspiracy of the act preparatory to the commission of the terrorist act as understood under the UAPA. The bench added, we have seen a very yeah we one more thing which I want to add here. We know the case of, there are so yeah a person named Muhammad Ilyas was 38 years old, and the Muhammad Irfan was 33-year old, was arrested in the year 2012 from Maharashtra, by Maharashtra Anti-Terrorist Squad, by the Unlawful Terrorist Prevention, upon the charges. After being a jail for 9 years, they all cleared from all the charges due to the lack of evidence on all the things. So the main thing is ki whether we are accusing and we are convicting any person. So on one hand, there are some hate speeches upon which we are not charging them against the UAPA, and there are many cases upon which we are just on a mere suspicion we are charging a person upon under UAPA. So this should definitely be seen, and this should definitely be amended after and the case is already pending in the Honorable Supreme Court of India. So let's what Supreme Court says. Now we come on the what is the the data and the figures of conviction under the UAPA Act. So as in the last in the Parliament in August 2021, government has given the figure that in 2019 there were 1,948 arrests have been made, and out of that only 34 have been convicted. In the last 7 years, in the same in the parliament, while answering a question, the honorable minister has said in the last 7 years, 10,522 Indians have been arrested under UAPA, and only 253 have been convicted. This is not. This is a serious issue. We all are supposed to look into it, that why the convictions are low. I'm not We cannot come on a conclusion directly that these are low only because the cases are politically motivated. No, you cannot say all the time that the cases are politically motivated. There are so many other reasons as well. Like if we come on the conviction rate, as per the NIA has the rate of conviction which NIA has said. NIA has categorically the into two categories: number of cases pending trial from the previous year and those sent for trial this year. Number of cases in which trial were completed, those that were disposed of without trial, and those still pending trial at the end of the year. So in the 7 year 2014 to 2020, an average 1,834 cases were sent for trial, which is 40.58% of the average yearly cases are for investigation. And but every year only on an average 4.5 of each completion, because we have seen there are so many cases where cases have been registered, and court is taking sorry, the police are taking years to just file the final report. So if police is taking or the investigating agencies are taking years to file the closer to file the final report. So we can come on a conclusion. This raises a deep suspicion that whether the cases which have been registered under these cases that are of serious nature, because if they are of serious nature, then the investigation agency should have filed the completion final report at the best possible earliest possible way, but they have not done so. And accordingly, there are so many cases upon which the rise of cases and the rise of cases and the pendency of cases has also been decided. In the year 2014 to 20, an average 4,250 UAPA cases are queued up for investigation. And by the end of the year, an average of 3,579 cases are around 85% are still pending investigation, which I was earlier speaking about. There are so many cases upon which case have been registered, but investigations are running for years. So this creates a doubt. The crime data sheds light to the amount of the UAPA cases or standby owning the pending investigation. At the end of 2020, 4,101 cases were still pending investigation, but 44.33% of them, or 1,818 cases, have been awaiting investigation for more than 3 years, and 34.1% or 1,395 cases have been pending for 1 year to 3 years. In the last 4 years, an average of 42.42 cases awaiting investigation are 1 year to 3 years old, and 33.4 are more than 3 years old. So we have to see there are so many cases upon which investigating agencies are failed to complete the investigation within a time frame. So it creates a serious that whether you want to you are registering the case just for the sake of registering, or you really want to get the justice or to punish the person who have been charged. So these are some of the major things which we need to see before deciding upon the before coming on the conclusion. So after, if I conclude my small speech, that what have we learned from this, that I find there are, we cannot say that all the cases which have been registered under UAPA are false. No, we cannot say, because there are so many cases which have been registered under UAPA, might be correct, might not be correct. That is a matter of judicial intervention, and judiciary has a right to declare whether the person is guilty or not. But there are but some of the factors which I find that these are the reasons upon which the conviction rate is low is that the first thing is due to the act is very much complicated, and it does not define so many things properly, like who are the members, the funding part, that we cannot any person on a mere suspicion a person has been charged, and upon the trial, obviously the court, when the court goes into the deep depth of the case, it finds that the person is not guilty. So mere suspicion can be a part. We can say there are so many things which are not defined properly, upon which the cases are the conviction rate is low. There are so many cases upon which the government intervention is also, it cannot be set aside, that yes, there are so many cases which are influenced by the government. So these are some of the aspects upon which we can say that these are the reason upon which the cases has been rising and the conviction is low. Yeah, the one more thing, our investigating agencies are not properly equipped with the modern technologies. We are lacking with the forensic technologies. Like I am doing my masters in forensic science. I can say when I was attending my lecture from in Nalsar, there are very few good forensic labs still in India. So there are so many modern technologies on which our forensic our investigating agencies are lacking. We are still running on the danda pratha, that if you want to take something from anyone, just start beating with danda, and he will. But you will take out anything which you want to take out by beating a person. But when it comes to court does not beat you from a danda. It when you adjudicate the case properly, when it goes to the deep of the case, it finds it goes into the merit of the case. Then it comes on court comes upon a conclusion that whether the person is guilty or not. So these are some of the things. We cannot conclude upon political rivalry only, and we cannot conclude upon the act only. There are so many factors. There are upon so many factors upon the investigating agencies also. Political influences cases are also a lackness of a lack of law, not lack of law, we can say that the law is not there are so many things which are ambiguous. That's why mere suspicion, upon a mere suspicion, a person has been arrested. So these are the factors upon which we can say the cases are rising, but the conviction is low. But so these are my submission, and these are my, I'm concluding my speech over here. If anything, if anyone wants to ask anything, is most welcome.
If anyone wants to ask any question, they may raise their hands and we will take the questions one by one. I would like to repeat myself. If anyone is having questions, they may ask it. If there are no questions, so we may conclude the session. And thank you so much, sir, for enlightening us on this crucial topic. And it was a
Hello.
wonderful session.
Yeah, hi, Rina. Hello.
Yeah.
Yeah,
Yes, sir. We have some questions on the chat box. Please check the chat box, sir. Uh,
Okay, so let's check the question one by one in the chat box.
yeah. You read the message, I will, and read it to me, and then I will answer.
Rini Mishra, please read the all
Yeah.
the messages.
So some of the requests are for repeating the case names, whatever you have mentioned, and I don't think any different question has come. If anybody is having any doubt, they can just post it in the comment section. Sir, one question is there related to Nia versus Zahoor Ahmad Shahid. case, if you can
Yeah,
enlighten us.
uh, I have to go through the case because without going through the case upon because there are so many cases upon which if someone asks me a particular question that upon which category they are asking, because if we ask there are number of cases, so it is very much of a, and any case which is still sub judice, so it is not proper to say anything upon that case.
Okay, so I don't think now we have any questions. Sir, yes, there is one question. There again two categories under NIA which you mentioned in between the explanation. Can you
Sorry.
mention categories? Can you mention two categories under NIA which you mentioned in between the explanation?
Okay, actually, in the 2019 amendment, government has amended and given the power of investigation the cases of under the UAPA to the NIA, and NIA has the power in how NIA basically investigate any case. NIA investigate the case upon when the state government request to the central government that this case we want to investigate through the NIA, so the case will be invested upon, by the NIA, and if central government on a suo motu wants to finds that this case is fit to be investigated by the NIA, so NIA has a power to investigate those kind of cases, because NIA has also been amended recently, upon which NIA has been given power to investigate this kind of cases nationwide. Like NCB has been given power to take the cases relating to drugs and psychotropic substances.
So now I think we should conclude the session because we don't have any more questions. Uh, Thank you so much, sir, for joining us and enlightening us on this topic. It was a wonderful session. So I would now we should take leave.
Thank you so
Thank you
much,
so
Nishant sir, for this wonderful session.
thank you so much. Thank you so much, everyone.